complete all this bail carrying on. Yes. Yes. Yeah. Yes.
Item number 4 may be taken up tomorrow along with any number Q1.
Wait till 4 is called. Wait till 4 is called.
Yes, sir.
Yes. Do you know why this matter is listed? Do you know why this matter is listed? Item number 10.
Yes, Lordship, today I have filed additional
When have you filed?
today, Lordship.
Okay. It is stated that additional affidavit has been filed today. Registry to verify and take the same. List this matter after 4 weeks.
2 weeks.
Done.
Sure.
Done can wait.
Item 43. It will be listed before appropriate time.
I'm not getting what appropriate bench, why appropriate.
Earlier, the bail was granted by my lord, Justice Surana. So we have filed an application for cancellation of it.
It is submitted that this matter should be listed. It is submitted by the learned counsel for the petitioner that this matter is required to be listed before a coordinate bench. Within bracket, Mr. Surana J. who's the registry to verify and list accordingly.
Yes. Motion tomorrow. Regular basis.
Yes, that's 22. Any interim? When?
November.
7th of November. Interim to continue. Criminal petition go to the senior. 38. 38. Yes, that's
30.
you wait. If CD is there, you wait. We'll see. Yes. Matter pertains to all BA and AB allowed. No need to mention. Item number? Yes, that's okay. No, adjournment rejected.
Motion BA, item number 2.
I've seen that. CD.
Along with the medical
Be under treatment.
under treatment but not satisfactory. In section 29.
Along with the medical report. You are in a base hospital in Assam, Guwahati Medical College.
That's true, my lord.
Huh?
It might not be.
That is the best hospital as on date in Assam. You want to go outside?
Private hospital, my lord, is not allowed.
We'll see that.
Alright.
Item 3,
City. When does?
27.
27.
4,
City.
Tomorrow.
It is submitted that case diary in another case has been called and same is fixed tomorrow. Accordingly, list this matter tomorrow along with.
Item number 47.
I do not know item number. Can you write this item number 47? Yes.
5,
Sensitive matter.
Scan copy and including the CD. Scan copy of the case record along with the CD. Scan copy of this by the registry. And then write.
Much of this.
When? After 3 weeks, give it
November, first November.
hospital. No way out, because otherwise it will not come. We have seen that. Kamrup is worse.
Much of this.
8 November. Item 6,
EA number 288520.
CD and the when that other is
290920.
290923 along with
EA number 288520.
that accident.
This is the time.
item 7,
Is there? Is there?
29.
29.
8,
And the call for the 30 days. Allegation of the receiving.
PMAY scheme. How many days?
30 days. Allegation of
You are the
5 years there, and I have no connection with any of law. Since my wife is the president of the company. It's only for the political budget for the disability fine after another 5 years.
incident of how many days?
30 days, 33 days.
You are not the president.
No,
You
fine,
you
fine.
just let him go 5 years back. To the satisfaction of
And CBM, yes,
SDB.
sorry.
Being husband, fine, 30 days is fine.
supplementary item 53,
Where is the FIR? Oh, this is Sarcite. Or what? Kidnapping. Sarcite case, huh?
Can copy has to be perfect.
Scan copies. You wanted bail day 1 today? That your senior, huh? Senior is not required, case diary. Keep a scan copies of the case record along with the case diary of so and so PS case number so and so. When earlier date we fixed, it is from Kokrajhar, Bongaigaon.
Idea about.
No, this is from Bongaigaon. When?
First of November.
First of
It is a holiday.
Holiday.
Eight of.
8 of them.
54,
Ramsway School, madam. Page 11 is the apartment.
Page 11.
11 is the apartment. Second number, school around 2 a.m.
This is motion or bail hearing?
Motion.
B8,
Motion?
B8, supplementary.
Okay, supplementary list. Okay, this Nagaon or Shivsagar.
It's a Lakwa 6 hours.
Now, who are you?
Admittedly, page 30, madam. Second paragraph.
Atar Ali,
No, the people.
Rafiqul Ali.
I purchased, madam. I told you. Admittedly.
How many days?
17 days.
Recovered,
Recover.
cable is recovered.
Recover.
Otherwise, what do you do?
Scrap the earth to government.
To the satisfaction of
CGM. Sorry. Sorry, madam. SDGM, RGM.
SDM Nazir.
I'm operating.
Item 9, motion AB,
That's also create for create the symptom and because of tender the higher. What kind of a page madam?
Yes,
Because of business, monetary transaction between the parties, my lord. They paid my lord. Other was already arrested, my lord. They did.
no, we have dealt with some other cases also. These are the modus operandi.
No, I
Some-
was there, my lord. I was, because present petitioner as well as number 2,
Mm.
along with informant has some survived in the situation, my lord. He was supposed to pay with his lifetime to the petitioner.
For that you will,
No, that was, I was not there at all, my lord. Right? In the petrol pump itself, my lord, when they were doing the petrol, my lord, there.
what is your name?
My name is Madam Rafiqul Islam. And Sabir, Dajjal and Shahidullah, they are fitted my name.
And 4 other persons.
four others. But my name is known to him, man, because I
Then why are you apprehending?
why I have paid it because my relation, I have stated your worship, business relation with him. So police have paid 4 my lord, they have paid it over. Because of business relation with him, so police also come to my house. And 50,000 rupees my lord, they have taken, they have taken away. Another 50,000.
This is not a case for anticipatory report.
Why do it is, I think about the subject of what system, I did.
Considering that petitioner is not named as accused in the affair, this court will of the view that able to made out a case for interim protection. Within 10 days, appear before the IED. No interim actually, it's only interim within 10 days. Huh? CD. Date, task will be
8 of November.
8 of them.
Hours.
3 line to look for.
Motion. matters, item 11,
So the whole of the application.
Heard Mr. S. Nawaz, learned counsel for the petitioner, also heard Mr. Das, public, additional public prosecutor for the state of Assam. Full stop. The present application is filed, assailing so and so, so and so, so and so. Thank you. Issue notice, returnable, your date after vacation. It is notice on 11/11/2022. This is a working day, 14/11/2022. 14/11/2022. Steps upon respondents, Mr. Das accept notice on behalf of respondent number 1. The other side is a party.
Yes, my lord.
Okay, respondent number
2.
2. Respondent number 2 is. Then considering the dispute and also considering the pendency of the similar dispute before the National Company Law Tribunal, Guwahati, as well as the criminal petition /1035/2022 filed by the respondent number two and other shareholders alleging certain misappropriation against the present petitioner. This court is of the view that the petitioner has been able to make a case for interim protection. Accordingly, till return of such notice, the further proceeding of so and so shall remain stayed. The present criminal petition or criminal petition to be listed along with criminal petitions /1035/2022 on the next returnable date.
Bail hearing, BA item 14.
Pending disposal, Sasur, go and file an application. No, that may be 100,000 days also, but that may not be granted during the trial. What is the allegation? 302. So you want that we should, without going through the statements, grant you bail. Huh? It is submitted that during the pendency of the present application, already search sheet has been laid. So accordingly, the present being CS number
257.
dated
31/7.
2023. In view of the above, the present bail application stands closed with a liberty to the petitioner to approach the trial court for grant of regular bail, and in the event of such filing of such application, the learned trial court shall consider the same in accordance with law.
Item 15.
16 minutes. If there is no there.
No, just a minute. Void and scan copies call for.
Pending disposal of this petition minor, the 30 days is okay. So minor is one of plus Q2, also that can copy of the CD along with that.
Oh, no.
The 30 days is high for the SPO code. Sometimes my note the 30 days is not late, high because the SPO. That's not for what side.
Yes, next.
15.
Obliged.
CD is not there. Where is the affair? Tell us. Everybody should be ready in this court. Where is the affair?
Transfer copy is taken.
Huh?
Is a transfer copy. Another copy is
Not legible. That's the foreign language is very difficult. When class? How many days? 302. specific allegation,
I try on your 25th of
25, specific allegation.
Provocation was there, madam. Only
No, provocation is there, I understand, but as a prima facie specific allegation of beating and the death, that is there. So let us verify that may be a grave and sudden provocation, that is a matter of trial. That may be 304 part B, that is it.
There is no intention.
No, that we will have be able to see from the case diary. Otherwise, considering this, we would have considered, but it's 302. When? Even early date,
25th September.
25th, otherwise on that we will conceive and consider without it. Yes. Why you need your senior?
Madam,
Why she said that senior? Why?
16,
Yes, yes, also. Okay.
Yes,
It is a property and regulation.
yes.
Elevator under section. That 384 and subsequently added section 302 and 201 side. As a case 9.
So many ransom, demand of ransom and killing. Series there, what is his role?
It's a long statement. It will take case of 2015.
Uh,
The mother victim has not yet been recovered till now.
no.
So he has been arrested on the basis of the going to.
Okay, now, the fact is that allegation is that there was a demand of ransom from through a phone. Phone number belongs to whom?
Like a phone number and this particular, this actual person who was present noted, the victim noted, he was taken to those person.
Hmm.
And mother, he took some harm noted, he took some harm.
Hmm.
Then this person took him by crossing the river and handed over to this person.
So they are transporter.
If they are not, he is not transporter, okay?
Hmm.
He is the person under whose custody the actual person was given. They are
Okay, so if the transporter deliver it to him,
Only him, there is other actual person also, but he was also one of the members.
one of the member, and what is the stage of investigation?
Investigation was the other actual person is yet to be arrested.
How many days? Be they are rejected.
I will.
item 17,
Yes. Considering the material available against the present petitioner, including the fact that the victim was delivered by some other co-accused to this person. This court is of the full stop. This court also under consideration, this court has also considered that some of the co-accused are still at large and police are trying to apprehend them. Considering the matter in entirety, including the nature and role of the present petitioner, the present bail application stands rejected. Yes, yes. What is the affair?
498, my lord, where is the place?
Now it is a translation from another foreign language. Yes,
Page 9, my lord, and there is the. There is no.
he is an interim
No, my lord, it is a BA. BA,
VA.
and the petitioner number 2 is not involved, my lord, and he is not.
Just let us understand what is the allegation against you. Who are you?
And the mother and son, my lord, husband, my lord.
Specific allegation is against you. You are a mother and
Mother and.
son. Huh?
I was.
Okay, we'll see the case diary.
My lord, petitioner number 2 is not present.
We'll see that.
And 36 is already-
We'll see that. When, Mr. Burra?
22.
22.
18,
The lady has died.
No, he is alive.
Any state?
Just-
Huh?
He is very calm.
If you have it because they are inside.
I'm praying
Otherwise,
for-
you'll consider on the next day.
I'm praying for that one.
Come together. We have done everything together.
He is not.
item 18,
Yes. 39, where is the affair? Page 11. What is your name? Babul Jesuar. Series there. Be there. At least some other will be saved. I am now very reserved in this kind of cases. They have made the life of citizens hell. Nobody can go out for you. When?
One thing. He has already completed 65 notices.
Okay.
There are two parts.
Yes.
The first part is 60 days of.
First part is 60 days. Now he is first part or second part.
Whoever commits robbery shall be punished with regular supervision for the whose extent of 10 years.
Hmm.
If extent of 10 years, then it will come to 60 years.
If extend to 10 years, it will 60. Now how many days?
65 days.
So default bail. No search sheet file.
No, that I have no notion whether satisfied or not.
You have a instruction will allow him to. Wait for some time. Wait for some time. Let him have an instruction.
item 19,
Yes.
Let's get lost.
Yes.
Okay, there is no.
302. What is okay? When? At least 439 CD should come. People are inside, will either we give them, even we may not give it on 59 days. That is not an issue.
29.
29. Just instruct the IO, at least 439 CD should come on the day one. Yes.
item 20,
Yes.
I'm not named after the also my name is not.
Charge sheet also not your death. By 313, 319. Or what? Your name is not in the charge sheet. Then why are you here? Oh, your name is in the charge sheet. Not in the.
All the accused persons are in the
Go through it. Already there. Everything is there. Go through it. Assist us. Day after tomorrow. Please this matter day after tomorrow. In the meantime, the learned additional public prosecutor may go through the scanned copies of PRC case number 861/2023 to assist this court. Flag market, what is his role? If everybody is outside, why should he be?
item 55 of supplementary list,
Love, you have not reached the age of love and affection. Problem is there. There is a problem is that Parliament has fixed a date for year for love and affection, and you have. Yes, he is 19. He is 19.
He is 16 years notice, last year,
then Manoj, he was taken to his place.
Hmm.
He stayed there also, but regarding notice that any Manoj citizen, that is not clear also.
And then what is her statement?
I said, "No, no, no."
He is also 19, just crossed.
It is very clear of it now. It's a law. Last line of this is not clear.
Preparing the statement of the victim bar and period of detention. How many days? Don't be so affectionate in future. Yes.
Bail hearing item 21.
No.
No, there's a discussion.
To the satisfaction of?
Citizen, right,
Yes. Yes.
pass on.
She is evasive. Yes. Item?
21.
Non-appears for a petitioner on call. Use this matter. After tomorrow, case diary be written.
15,
No, 15,
59.
15.
Item number 23.
Any interim? Oh, this is scan copies of the case record GR case. That is there. Not today. Not today. The other video, we may go through the same and give it. About the remove the additional publication may go to the scan copies received. 15/9 or thereafter. 15/9 interim order pass less continue. Go through it. That is there.
Item 24.
Yes, when Mr. Das, November, after 10.
Yes.
Yes, case number 105/2023 under section C76(2)K, C76(2), 506, Lakhimpur. Okay. When after 10, you know,
13th of November.
13th of November, interim to continue. I think 14.
Item 25.
When? November 9th. Interim to continue.
Item 26.
Yes,
Interim there, my letter.
sheet is there again. Interim to continue. Nine number.
Right.
27,
Why 2 meters? We'll file after search sheet or yes, Mr. You have filed bail after search sheet or during pendency. This is, huh?
Submitted on 31/7/23.
Interim. Tribal by 325/307. Sessions. Sessions. Dispose of. AB 2430
Yes, madam.
till appearance and committal. Interim will continue. Dispose of.
28.
Thus, are you having the CS number?
Yeah.
Huh? In this case,
Yes,
yes. Being CS number
287 of 23,
287 of 23 dated
dated 31/7/20.
Item 28.
24, I'm sorry, dated on
interim is there. Interim order pass earlier cycle. Interim order pass on 2/20/07/2023 shall continue. Your interim was not extended on 17/8.
58.
Item number 29.
Yes. When?
15.
15. Interim to continue.
Item 30.
Consider. That's why I think he's not present. That's why not. Okay, it is non-appears for the petitioner on call. The search sheet has been
Number is not there. We have ceremony is something.
okay.
So we have
In view of that, the
from next week.
list accordingly. If the non-appears for the petitioner on call. However, in the interest of justice, matters that's adjourned and be listed on
19.
19th.
Item 31.
You can just take over it.
Please. Revenue tax fund.
Sid is there?
Report is not.
Only on submission.
Here on interim.
Yes, revenue tax fund. Yeah, you go. In respect, this is reporting that on last 3/5/2023.
Though the case diary is received, however, the postmortem report is not yet received. Full stop. Full stop. This court is of the view that for proper adjudication of this bail application, anticipatory bail application, the case diary shall be necessary. Necessary in as much as according to the FIR, the dead body was found floating in river Brahmaputra. Accordingly, list this matter on 9/10. 9/10 case diary received be returned. Interim order pass earlier shall continue.
32.
When? 10. Interim to continue.
33.
City is there.
Yes, yeah.
Where is the FIR? First tell us. You are Arup Boshra. Skip the case. Then. What is the case?
There is no PM because one thing is in my bed, that deputy was found.
No, that we understand. But why these two persons are specifically named?
Come up to the table, he did my love. It was my love, he was taken up. And
No, no, beaten up we understand, but two names, why, on what basis these two names are given, and what is your investigation regarding these two persons? Yes, no, you will say, just I want, what is the investigating officer's view?
the thing is, my love. Regarding my love, that part, my love, there is silence in the city. My love.
That is the main part.
Yes. And now, my love,
Why two persons are specifically named?
yes, yes.
Because what is the statement of this Gani Ali? Gani must have some information from somebody because he was not present. Then that person's statement is required.
Yes.
Who intimated Gani?
Gani is there, my love.
If you want to want some time to go through it, you
Yes,
can.
yes, because my because PM is also required, that is, because my he was beaten up and was dead body was found in the own.
Maybe in front of
In a-
their house, that may be.
Yes, no, he was from the old,
Understand. There was an allegation that this person was beaten up by A and B.
Yes.
Why this allegation and what is the material against them? That's all.
Yes.
They say that this happened or something has happened in front of us. We are falsely been implicated. That's all.
And our statements are recorded in the tape.
Mm.
It is not their name, nothing apart from it. Killing party is different.
Okay, so do you want to go through it?
Yes, I was thinking, also I will take the whether PM is there or not.
These are serious cases. If you are half-hearted,
No, usually they kindly provided, but I'm not sure we are running away from.
you run away for some time. It's good to burn calories. Yes,
Monday,
Monday. Go through it and Monday or Friday, whichever. Monday. In the meantime, the postmortem report be produced.
18.
Yes, yes.
7 days.
On the prayer of the learned additional public prosecutor, the matter stands adjourned and be listed on 18/9, on which date the case diary along with the postmortem report be invariably produced before this court. Otherwise, this court,
One or two cases, I can number 56 together.
56, okay.
Highly ordered. Thank you.
Item 34.
Time being, CD is there, that's, but where is the FIR? Why you should adjourn for time being, tell us. Are you with the brief is with you? Yes, come to the page 12, FIR, read it.
The order from due to parking. It's very simple. We believe that the informant states that the accused person is an aggressive person on second of 2/8/2023 at about 9:30 p.m. The accused party parked his vehicle by
What is your name? Your name?
PWD.
Hart Mr. P. Devi, learned counsel for the petition. Huh? Here is the case there, considering the material available on record and the injury report, which is simple. And this court is of the view that no custodial interrogation shall be necessary. Accordingly, the present application stands allowed with the following condition.
35,
Always come prepared with your brief. No senior is required in this court. No, it's AB.
Sometimes will also is
35.
35. Is there, are you on interim? Interim order may be passed. Why? It was not passed. Why?
The accused number one is involved in the crime, but rest are innocent.
Rest are innocent.
and we give it some.
Your name accused. Sukur Ali. You are accused number 4. When?
Hello.
Third of all. Specific allegation is against one, but it is said that the accused persons and you are named. That's why you are not considering it. That's why interim was not granted. Yes, next case.
36,
Hey, last date bill has there is a mistake in our language. 16 on September, it went to October BA. Date be careful.
9, 10, 11.
Yes. Is the receipt thus? What is the FR?
The allegation is against 2%. Here you are only 1% of the close. Allegation is against 2%. Here only 1% of the close. The allegation is that in the name of providing PNJY house, the accused person has demanded some money from the account.
Who are you?
I'm the accused.
No, I know you are the accused. That's why before it. You are the member. We have granted the husband of the president in similar cases. But you are a member, specific allegation that you are demanding 5,000, 2,000.
But see, I have no one granting money or providing house.
What is it? No, we have rejected yesterday of the Dev or some government. We are not having any leniency towards this elected representative. It means appropriating the benefit of the citizens. Arrested, rejected. Considering that most of the beneficiaries, who wrote it? As they stated, most of the witnesses. The statement recorded by the investigating officer under section 161 of different villagers clearly reveals the involvement of the present petitioner in commission of the alleged offences. In that view of the matter, this court is not inclined to grant privilege of pre-arrest bail to the present prisoner. Accordingly, it stands rejected. Earlier interim order, if any, stands back. Okay.
37,
None appears for the petitioner on the call. case the recall for is not received, petitioner is on interim protection. And then, list this matter on
9, 10.
9, 10 or case the interim to continue. Generally,
38,
Yes.
Find the password of the matter. And
cities there.
it is there.
Why should we time pass over?
Continue on the way.
Are you having the brief? Kindly come to page 8. Till your senior reaches, let us read this.
The super insurance of Samarkand City. The due respect has existed on 4/8/2023, Friday night at 9 p.m. Carrying a sharp weapon, mattered out in his hand, Sri Mohendra Sotia, son of Digleswar Sotia, in Kamangam district.
What is the injury?
And the injury, so medical report is not clear, it is awaited, but injury, it was sustained in the head, it's a case of 307.
307 is there because it's a sharp weapon. Weapon is seized.
Weapon is seized and it is a Nagada.
Nagada. That is there. Where is the cross? Where is the cross affair? Page 15. Huh? Next up to page 15. Who is this Prasurja Sakya? Mohendra's son. When this was filed? On 11/8. An actual incident happened on 6/8. Who is Bharati Sakya?
The party sector is the wife of this petitioner. When he suspected there are some.
This petitioner that Mohendra Sakya. Mohendra Sakya's wife used to visit this person without his permission.
And that's why.
2-3 times a week.
That is why he suspected there is some relationship with this victim. And therefore, he went to the house and assaulted murder. It is her sister's house.
This is not a case for,
No, actually.
this is not a case for anticipatory litigation.
I have.
Your wife is having a relation with somebody else. Can you attempt to kill that person? Get divorce, file a petition for divorce.
In fact, that day the incident started when I have filed an FIR against them.
On 11/8.
Against, because I was injured when I the photography loss, you will see half of my feet has been almost chopped off. They got anticipatory pain, which is why today morning I was trying to get a copy of that. Just now I got a copy. This morning I made a mention that I want to bring it on record by the incident. The other side, who have previously injured me, they are on anticipatory by the session. The order I have in my cell phone.
You file it by tomorrow. We are taking it up on Monday. Okay. It is submitted that in the alleged incident wherein the victim got injured, the present petitioner was also seriously injured, and an FIR was lodged. Full stop. A SFR is lodged against the victim in the present case. Full stop. The victim approached the Learned Sessions Court, and accordingly, the victim was granted anticipatory bail. Full stop. The Learned Counsel for the petitioner prays that he may be allowed to bring on record the aforesaid order by way of an affidavit. Full stop. Prayer is allowed. List this matter on 89. The such affidavit be filed by Friday on by 15/9/2020.
39.
Who is the FIR, Mr. Burua? Electric connection. Why did they give electric connection?
Because to protect their land from the like animals and other things like that, you provide it. And illegally, the electric connection has been, and he being a person, when he in trespassing to that land matter, they are telling.
This is not the 302.
If you look at all these four, and if you also. If you go here, down, and.
Any-
Registered as a digital government.
304. No, they are already on interim.
One person is, one was an entry because you get for every identity because you're not connected it. And you can hear
Any requirement of custodial, the custodial,
for their act by the one person.
no, that's correct, but you'll have to balance, Mr. So,
The referee will decide after a long time, then after 23 days. Our cell was not available at the time. He was.
give the case. I do not think this is a case of custodial interrogation. Hmm. Okay. The material so far collected reveals that the petitioners put electric fencing to protect your paddy field from animals and enclosure.
It is up to my campaign. Against their.
Will not say, everybody will appear. Reveals the petitioner put fencing to protect their paddy fields and protect their paddy fields with raised electric fencing. And the victim, while going there, touched such electric fencing, and due to shock from such electric fencing had expired. Full stop. the stage of investigation as well as material so far collected and the nature of involvement of the present petitioner. If the considered opinion of this court do not warrant their custodial interrogation, inasmuch as their statement can all be inasmuch as pathological infection to stop. Accordingly, present is evidence with the following conditions. They will appear within 10 days, get their statements recorded, will shall not leave. Okay. And
Shall not do well such activities.
such and shall not do such activities in future.
Item 40,
Is there is there is a FIR? Give a statement.
Both of them are picture.
Huh?
Both of them are picture.
Oh, both of them are teacher. Why have you not said on the first day, Mr. Sharma, that she is also a teacher? Considering the statement of the victim recorded under section 164 as well as under 160. Yes, that they will do. Allowed with the condition that he will appear before the IO within a period of 10 days, shall not leave the jurisdiction of the police station without leave, and appear before him as and when called for by the investigating officer. আর এখানে যেটা আমি লিখেছিলাম not influencing witness and sir case study referendum.
timing item 18,
Case study 18 Harshit submitted 18 Harshit submitted being Harshit number
Number of 155 of 2023, dated 5/9/2023, under 395.
accordingly 392 shall be triable by session. So propose the sessions ko jurisdictional sessions ko and seek regular bail, and in the event such application is filed, shall be considered as per law.
for orders item number 41,
Yes. Why? Why you need your senior? What is the service report? Yes, sir. Okay. Peruse the office note dated. Your responsibility is to look into the orders. Order sheet and not sheet. For that you do not require your senior. You require. Not require. Peruse the office note dated 16/8/2023 and the service report from the CGM Thubri, full stop. In view of the report of the learned CGM Thubri, the service in respect of respondent number 2 is complete. Full stop. List this matter in the accordingly. Okay, service is complete. Accordingly, this matter is ready as regard service. Okay, LCR is received. Okay, LCR has also been received. Okay, now accordingly, list the present application is filed under section 389(2) CRPC for suspending the execution of sentence and conviction and to release the accused appellant in bail who is in jail in connection with the judgment and order dated 29/4/2023 passed in session case number 341/2018 by the learned Session Judge Dhubri, whereby the present applicant has been convicted under section 370 within bracket 2/34 IPC. Full stop. As the service has recently been served, completed, let this matter be listed. Let this matter be listed on give a date prior to vacation.
18th of October.
18th of October 2023. In the meantime, Mr. Bu, the additional public prosecutor may go through the record. You also get through that on next date we will consider. The present application shall be considered on the next date fix. List it on due to date this year.
Number 42.
What is this IA?
Basically, just pure. But whatever, why does pilot based on domestic violence act? Before the division makes the first class as problem. My learned friend has challenged that order. That if they are parallel two proceedings cannot go. That's the issue. And the protection was filed under section BPX that is going on, and if we see the another case for return of the freedom, the 406. So that is under stay. We have come before you have to vacate this job. Then go back,
This-
both the proceedings can run together.
This criminal petition 785 relates to offense under section 406.
Yes, yes.
That cognizance has been taken.
They can
Now this proceeding is stayed. So let us hear this matter.
do what?
We'll hear this matter right now.
Yes.
Yes, proceed.
By only terms of that, my lord, there are two parallel proceedings, my lord, this cannot work.
Parallel proceeding of what?
My lord, one TV proceeding is similar relief, my lord.
What similar relief DB proceeding? DB proceeding is a civil in nature.
They will make it, but that proceeding also, my lord, they have paid for the recovery of the state and property.
Maybe
Here also, my lord, in this criminal petition, they have also.
will that DB will have a power to issue a warrant
Not
to recover? Where is that power? To us.
After
Sir.
Take a look.
Why don't you give it her back?
The problem that my lord has not established something that my client is long. So I leave it to your lordship, my lord.
Okay, so since you are leaving it to this court, let this matter be listed in admission column. We come with orders matters, we do not come with preparation. List this matter on in the admission column on give a date before vacation,
18th of October.
18th of October 2020. three. As the parties are duly represented. I had liখিব, as the parties are duly represented, instead of taking the present IA, let the criminal petition be taken up at admission stage for final disposal. Accordingly, list this matter on 18/10/2023 in the admission court.
Item number 44.
Yes. I is for condonation of delay. First time listed notice. Who are the respondents? Notice returnable 6 weeks. Mr. Goswami accept notice on behalf of respondent number 1 for 2 registered as well as usual both ways. Within 5 days.
So orders item 57.
Or
I is for
consideration of paying on fiscal grounds. 90 days has been completed. To grade 93 days. Consider not.
succeed not filed. Have the instruction, we are taking up after some time. Moment you have the instruction, we'll take up this one.
Item 45 for postman.
Yeah. Yes, Provost, what is this? What you want to get cost?
My lord, by having this question, I have, my lord, wait for question of it. Question of them, my lord, Kashi, and the question of what.
Where is that?
My lord. Okay, kindly. One, five.
First, let us know where is the FIR. Page
882.
now, before that, let us know who are you?
I'm the, my lord, accused person, my lord, and it's full allegation of thing.
How many accused you there?
There are 3 accused persons.
All are before this court.
No. 2 accused persons were not, they didn't find any material. And there was made for discharge of those. Accused person's father and mother of the penalty.
Then this was discharged.
Yes.
A discharge was done.
Discharge was.
So only the husband.
Only the not husband. So for my lord, allegation is that there was a promise on my part to marry me. For street things.
Okay. So it is Pankaj Khatania. Others are discharged. So we need not bother about Nobin and Nirmala. Okay, where is the affair?
Apparently, is that paying to my lord.
80. 80.
Oh, 86, my lord. My lord, 86 is a particular. Affair and update copy, my lord. And pay 80. Okay, 82. 82. Did they get from the account which we don't? Please, don't. And according to her, there was a relation maintained by there will be an petition of 3 years. So, on 2014.
Okay, okay, then
That my lord,
where is her statement?
he made a statement,
Her statement,
that page, my lord,
88.
thank you. Now she developed a lot in her action by making statement of section 1 in 64. That Venus union was performed. But we found that in the affair there is no insecurity. Only addition is that there was a promise. And my lord, after 3 years, and she approved
Can we go through all these facts? Let him cross-examine her,
that to my lord.
isn't it? If that's true, we'll dismiss it.
No, my lord. There is a question raised by them, whether it is continuable. There are a number of districts, my lord, there is absolutely no uniform.
Okay.
If primarily appears that
Mm.
only offense is without. All my lord,
But just remind yourself that we are exercising power under 482.
that's my lord, I know my lord, I will say, my lord, all you have or there is.
Okay, then so page 88 is her 164.
Positive statement.
Hmm.
Madam Hanikula is at page 19. And she developed a statement, my lord, by
Okay.
inserting a new allegation that ring ceremony was performed. But absolutely, there is no ring ceremony because every appears from the affair. Whether a long continuous relation of 3 years,
Hmm.
that considering often that too much is a matter. Whether she has got the consent, whether she is a consenting party. That about my lord.
So what are the offense registered? What offense cognizance taken?
No cognizance taken because before taking cognizance come.
Before taking cognizance have come. You argue before the court, all those things.
Hello, therefore, my lord, then, my lord, I will apply the motion, my lord. It is absolutely, my lord, there is no impediment. On the part of the court, my lord, to my lord, entertain the question of commission.
No, there is no impediment. And there is no impediment making observation and rejecting on all the grounds.
Simply on the ground.
And that is the end of the road. Here, there is no downstairs,
My lord,
only upstairs.
there are a number of decisions on this.
Okay, show us the number of decisions. Two things, the FIR and her statement. That's all. On the basis of that, search sheet has been filed.
And charge sheet, you know, notified it, I will go to charge sheet.
Hmm.
Charge sheet, you know, I have given the original question as well as the type code.
Oh, for now, don't cite 1973. Cite recent judgment.
So at least one of the high discussion. That would take your working the road, the charge sheet.
Hmm.
Next page, my lord. 119.
Hmm.
So, Yes.
115.
May I give you a SMS button, and I will focus it.
Why? Are you having doubt on translation?
There is some amount, so there are translated, the time is. The following to color. I will okay got. At page 119. Following to color, উপরোক্ত,
119 is something different.
119.
100 and
19.
yes.
All right, second part.
Toronto cover.
Following to color. দুসরার উপরোক্ত দুসরার ঘটনাগুলি প্রযুক্ত করি। দুসরার নিয়ে কথা।
What are the offenses?
376, 496, and 420.
3,
376, 496, May I read it?
Yes.
Second para.
Hmm.
পদক্রিয়ার বিরুদ্ধে ভারতীয় সরি ম্যাডাম তদন্তকারী উপযুক্ত ঘটনাকে পরিশ্রম করে প্রতিরোধী তথা আনা সাক্ষীবাদী
Hmm. Hmm.
জবানবন্দি দোয়া দোয়া করা হয়েছিল তদন্তকারক সাক্ষীগণৰ স্বাক্ষৰ কৰা তথা সংশ্লিষ্ট চিকিৎসকৰ প্ৰতিবেদন মৰ্মে
Hmm.
গোপনীয়ভাৱে অনুসন্ধান কৰি দেখা যায় যে পদকীয়া শ্ৰী পংকজ খাটনিয়া তথা শ্ৰী নবীন খাটনিয়া ধূপগুৰি নুনতলা থানা লাহৰিগাঁও জিলা মৰিগাঁও অসমত বিয়া পাতিব বুলি কৈ তাইৰ লগত বেয়া কাম কৰি তাইক বিয়া নাপাতি সব প্ৰবঞ্চনা কৰি অন্য এজনীৰ বিয়া পতাৰ সাক্ষী প্ৰমাণ পোৱা যাব। You can find any material. Neither without allegation of cheating or breach of promise was found true.
Then what is the source? What is the source?
Charging, there is a promise and promise made clear that she continued despite her positive knowledge that she is the younger sister of my wife. And she accepted the proposal and she continued the relation.
Because your younger sister was a disease and she died, I think.
But if she is the younger sister of the petition.
Understand, but what happened to his wife?
Wife may not continue
Expired.
like that.
Expired.
Expired. And during the lifetime of the wife, there is no any question to make a promise. As a Russian knows, second marriage is absolutely not maintained with the third marriage. Why is the question on my part to make a promise? And why is the question for her to act upon that promise? She knows that. And Supreme Court says, my lord, if there is.
What is the date of your wife?
February 2017.
And when the affair was lost?
Affair was on 28 to 2017.
When your wife expired?
Around the first week of February 2017.
February 2017. Then
Then my lord,
when this affair was lost?
affair was lost, my lord, at page 82.
Tell me the date.
Yes. My lord, please, okay. At page
Don't say pages.
on 28 to 2017, offense took place. And affair was lost on 3/3/17.
Yes. No, Sachin, not certain. Huh? So you have filed this IA for what?
Or otherwise it was fixed from you. And later it for consideration of taking on the ground of default.
So he already default where he is entitled. Huh? What is the offense? Section 4 of POCSO. What is the punishment? 90 days, maximum is 90 days. It is
90 days.
already, how many days you have?
93 days.
93 days. Hard. Main bail hard learned counsel for the petitioner. Also hard. Mr. Borua learned additional public prosecutor. It is submitted by the police petitioner that the petitioner is behind bar for 93 days. As such, he is entitled for default based bail in terms of section
From 67 to
167 within bracket 2 of the CRPC. Full stop. Mr. Borua on instruction, on telephonic instruction from the IO submits that no charge sheet has yet been filed. Full stop. In view of the aforesaid, the present petitioner is allowed to go on bail, on furnishing of bail bond of rupees so and so to the satisfaction of CGM Dhemaji. Where is the forwarding? Special Judge Dhemaji. Special Judge Dhemaji. Post. It is BA pass koribo in view of the order passed in BA, nothing by BA. Case stands closed. Petition in person to pass on the hearing.
Item number 47.
Case diary.
Here there you have this, but what is the type of submit one thing. This case was originally created as
At Poltan Bazaar, then it was transferred to some Jalukbari.
Now they have received this case diary in the month of June.
Okay.
Now they have asked the informant to come to record his statement. So also the expert. But they have not appeared for.
Okay.
So there is no investigation as far as the Jalukbari case is concerned.
Okay. So now what is this application? Crossing. Crossing of FIR. Where is the FIR? At page 32.
My lord, this complaint letter is 29, case number 29.
It starts.
That's from 32.
That is what I have said. 32. Who lost this FIR?
My lord. Before starting, just now the one council submits that police station has submitted notice to me. So this is a false statement.
Okay, forget about those. Forget
I
about
have
those.
personally visited the police station and submitted the statement which I have given to the Patan Bazaar police station, and I have personally visited.
No. He said that after Poltan Bazaar, Jalukbari has issued notice not only to you, the informant also. But
2nd September, I have presented before the officer in charge, Jalukbari police station.
okay, fine. That's not the issue. Issue is you want to cause this FIR at page 32. Is that it? Now, and in exercise of power under section 482. That is your case. Now, since it is in the investigation stage, will you look into only the FIR? If a prima facie case is made out, we'll dismiss your petition. If prima facie case is not made out, we'll allow your petition. That much. CD, we may take help.
And by the secondary notice, the informant has been made party.
Uh,
Whether notices are to be removed, because it is a copy of the.
Because informant is not evading. We have seen different way notices tried to be served, but informant is not interested. But notice we have given a special direction. Registry to enquire and file a report whether the service has duly been effected upon response number 2 through the district magistrate Nagaon and place the same on record. On 9/8, there is no office note subsequent to this. Even if you want to quash, you have made the respondent number two party.
I have made the party, I have signed the notice.
Hmm.
But the basic fact is that.
No, no, before coming to the fact, is it not necessary to hear her?
My lord, document has been sent to his house.
Hmm.
He is very smartly, he has signature.
No, no, we have asked the deputy district magistrate Nagaon to serve and file a report. That report is not there. The office note dated 19/8/2023 reflects that registry has not received any report regarding service of notice in respect of the respondent number two from the district magistrate Nagaon till date. Registry shall issue a reminder forthwith and seek an explanation why after issuance of such reminder no report has been submitted and same be placed on record given it. Let us see your FIR. Huh? 19th of October. Ask the registry. Will not tolerate this.
So to retain the case that you will
You just retain the case there. Only on when we have fixed it? 19. Okay, case diary be returned back. And the statement you have when Jalukbari. See,
This is the Jalukbari police station.
let's give a copy to Borua. Copy to Borua.
the second of November, this case there is. Second of, yes,
Second of September. 2nd September.
it is that entry.
You verify. See, this time time and again I'm saying we'll ask for production of CCTV camera report and we'll take action against these police officers. Every case where statement is given to be recorded, the petitioner claims that I went there. He was busy on this pretext, that pretext, no statement is recorded. And in the CD, he will say that in view of, in spite of the interim order, he has not appeared. And if we find anybody that the petitioner has appeared and the IO has made a wrong statement, we'll ask for registration of the FIR against this IO. Please mind it and intimate all the police officers. This is not done. Many cases we have seen. There you have said he has not appeared. He is a smart guy. That's why he is having a proof. Now, what action should we take against this police officer?
I have also verified that the case there is absolutely. Where no 2023.
He has not done anything thereafter. If this person has gone to the police station, he has given a seal. Why he has not recorded the statement? At whose behest?
It was provided to our yesterday.
Should we record? We will say record all this. Case diary be returned back. Full stop. Returned back. It is submitted by the petitioner that he appeared before the IO and filed also an application which was duly received by the investigating officer of Jalukbari PS case number
341 of the 23.
341 of 2023. However, the case diary do not reflect any statement of the petitioner. The IO shall explain under what circumstances the statement of the accused has not been registered even after he made his appearance before the IO. On the next date fix.
A copy of the order.
Copy of the order be furnished to Mr. Borua. Okay, we'll take up on that day.
Talking to item number 1.
Mr. Give a copy of that Borua. You have a Xerox copy of that. And or a photo and WhatsApp it. What is disturbing us is three things. Yes, it is no quarrel on that the accused in his examination has stated that she actually who inflicted the blow or who poured kerosene, I have not seen. But that is also no way out, but that should have been, it is not a fact. Have you seen the sequence of the evidence? All these are suggestions. Among suggestions that was there. But instead of a comma, there is a full stop. You see the original. All earlier statements are it is not a fact, it is not a fact. And we also cannot verify whether it's a comma or a dari. See, a full stop and a comma makes a huge difference. Have you seen?
I am using my lord in different reasonable words.
Original I have seen. Here, yes, original I have seen. There is a dari. But all earlier things are suggestion. Anyway, we will not go to that and will not presume that this was a suggestion until and unless that is a suggestion. So it remains that he has said nobody. Now, how do you explain, according to us, subject to what you say, certain facts and incidents has been proved beyond any reasonable doubt. First, that the victim was found tied up with his hands, legs in a pipe of a tape in a burn condition. No quarrel on that. This is established by everybody, those who first entered. So that is established. So far relating to seizure at the place of occurrence, one witness, according to one witness, seizure is not proved. But according to the other witness, seizure is also proved. These two parts gone. Third is that he was brought in a burnt condition and the rope stuck into his hand due to fire was removed, his pant and underwear also removed by 2, 4 and 5, I think, or 5 or 6. Hospital staff, 2 hospital staff, that is also established. That immediately he was taken to hospital. Now, what remains is, now another question in our mind that why only one accused? Now, if we go to the FIR specifically states that it is you who has done the thing. Allegation is against you only in FIR. Now, FIR was lost on the next day of the incident. FIR was lost by the brother. Brother says after 3 days, the informant told him that it is the accused who did it, because for 3 days he was in unconscious state. Okay. Now, if that be so, there may be 2 views. One is, if you are aware that it was the appellant who did it, how can you lodge an FIR on the next day against the accused? Because he says he first time came to know after 3 days of the incident. Whereas in FIR, it has been written as by the accused. No other. So therefore, we cannot blame police not sending others to trial for the time being. Now, during cross-examination, the informant says that, yes, I do not know what is written in the FIR. What has been written, the FIR has been written by the police and I signed it. Okay, now where from police knows that this is the person? The IO states that the accused told him that it is the appellant who committed all those things. So whether these 2 things is corroborated, that yes, FIR was though lost by the informant, he was not present, he was in his house. On the basis of statement of the police, it was named, and after 3 days, it was stated by the victim himself That so whether these two evidence can be a corroborative evidence in terms of res gestae. This is one. Second part is this is one part in the mind of the court. Second part is that he is an injured witness victim. He had severe burn injuries. He was hospitalized for 1 month. So how it was happened, his description involving other 3 persons will lead to a acquittal of this accused, or whether the statement of the victim implicating the appellant number 1 still remain and is treated to be corroborated by the other evidences. His presence of common in the house, that was established. This is second. Other issue was fellow of his not saying I do not know who actually done, and all this contradiction will lead to an acquittal. This is in the mind of this court. Ultimately, one fact is established that the person was found in a burn condition, in a tied up condition in the bathroom of the accused. Let us have that part.
As regards when we go for section 6,
Yes.
section 6 will not come into play.
Okay. No, because see, these are very critical issues. See, one thing is that one offense is committed, so the accused should not go scot-free. At the same time, an innocent person should also not be behind bar for not doing a thing. So even after making it CAB, we gave our thoughts, started dictating, then different questions come. That's why I made it for mention, because let us again rethink this. 106,
No, 6 now.
section 6.
Relevancy of facts only part of the same thing.
Same thing, section. Evidence.
Here by not, in our case, the facts and circumstances of our.
Hmm.
Because in our case, the victim is alive.
Hmm.
That is the most important thing.
Victim is
In
alive.
most of the cases, we find that the victim is dead.
Hmm.
So in our case, victim is alive.
Okay.
Here by now, the IO has stated that when he arrived at the place of offense, the victim stated to him that Kamal Borua has done all this here.
Hmm.
But my lord, Kamal Borua
Hmm.
does not, my lord, state in his evidence 161 or anywhere that he has stated to that. Because here victim is alive, my lord. If he had stated to the, my lord, the investigating officer,
Hmm.
he have to have been stated that when he arrived there, that Kamal Borua has done so. But that is missing in all.
But IO said that victim told me that it is Kamal Borua who has done.
Yes.
But the time is not there, according to you, because proximity in a same incident,
Same transaction.
same transaction, the time is not disclosed when in fact it was said.
But as per my lord, whatever it has come into evidence,
Mm.
that first my lord, the neighboring people came in.
Mm.
When they saw the victim,
In
and
it-
they put the, my lord, his nylon,
Inform the police.
informed the police,
Mm.
and they found him that he is not in a position to speak.
Speak.
So subsequently, my lord, the police arrived at the place of.
Okay,
If my lord,
just a minute. Other witness says, other neighbors.
neighbor,
Position to speak. But so it's there itself is a. But you have not cross-examined the police on this point.
but for these witnesses were cross-examined. And police also wanted to help us.
No, you have crossed, but it was not that, there is no suggestion that he has not said you that it is Kamal or any, it is there, okay, we'll come. to it.
Coming to the evidence of the.
Okay, okay, okay.
And another part, my lord. Because this is a statement given by the my lord victim to the
Police.
police.
Now, whether that is,
Whether, my lord, that is the.
whether that can be relied on, because it is not by accused,
Because this is.
it
the
is by the victim.
Victim. And victim, my lord, nowhere in his evidence or in his 161 statement, nowhere he stated that when the police arrived, I told that it is common Borua who has put on fire on me. And on these two occasions, my lord, on third and fourth, my lord, these statements were recorded by the police and by the IO.
Okay, so there is nothing,
He is
nothing.
silent, my lord.
Mhm.
Oh, my lord, my humble submission before your lordship, my lord, this section 6
Mm.
of the evidence act will not come into play. Most of the cases will find in my lord.
Yes, yes, yes.
consistent evidence case.
That so and so came and said that immediately,
Then my lord, that person died.
or maybe the, they in a kind of a dying declaration, or that over telephone also
Yes.
sometimes, yes, then.
But in our case, my lord, that is the difference. Because in every case, my lord, facts and circumstances of the cases
Is to be
are
decided.
very, very important. So, my lord, my humble submission before your lordship, my lord,
Mm.
that section 6 of the evidence will not come into play in our case.
Okay. Okay. Okay, this is one.
This is one part, my lord.
Then explanation by Kamal.
By the accused, my lord.
Yes.
That has to be, my lord, 106, my lord, that is the special knowledge of the, my lord, accused.
Mm. So suppose in a last scene together, last scene together, it is established that they were last seen together and dead body was found after 3 years. So he'll have to explain what happened
Why-
3 hours. He'll have to explain what happened during, what was his explanation. That he should give, that after we met, I went to such and such place, he said then goodbye to and when.
Yes.
There must be some explanation.
Yes.
What is he, according to you, why one?
Burden of proving fact, especially within knowledge.
Hmm.
When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him.
Hmm.
But in this, my lord, 106, my lord, prior to my lord, putting this 106, my lord, prosecution has come to a conclusion that accused is the person who has committed it. And there is nobody else, my lord. But in our case, my lord, there are 4 persons with it.
Hmm.
That is not within the only the special knowledge of the my lord accused. But burden is always on the prosecution. my lord.
Yes, yes.
But in our case, my lord, as prosecution has failed to prove, my lord, that yes, my lord, whether can my lord the accused be.
So your argument will be from the evidence of the victim itself,
Yes,
there were 4 persons.
yes,
So it cannot be a special knowledge of the appellant only.
yes. There are 4 other persons.
Other
were
person.
there. And my lord, my case is that, my lord, in our case, my lord, 2 defense witnesses were examined. And I have stated in my 313 statement also there, my. At the time of offense.
You are in a shop or
Shop,
shop.
my lord, which is about, my lord, a mile or so away. And I was informed by somebody, my lord, that has been spoken by my lord, the DW1 and DW3. The, my lord, the landlady of the, my lord, proprietor of the shop. They have stated, my lord, that I was there in the shop, my lord, that one boy, my lord, I
Huh.
give the name, my lord. He came and informed Dilip Purva. Dilip, huh? Dilip Purva, he came and
Informed that something has happened,
happened in your house.
so
And
he,
then I did not take the mind of the grocery items which I have ordered there in the shop, and immediately I rushed to the house. Oh, dear my lord,
who did it? That is the issue.
that is dear my lord, but when, my lord.
Who did it?
Reasonable doubt.
Yes, yes, no, that's why we have made it, listed it today. Yes, Gotthakul, what is your case now?
First of all, your lordship has pointed out that yes, some incident happened on 3/1/2004. That on the next day, FIR laws on 3/1/2004.
Mr. Chaudhary, Ujjwal, give a note on your arguments corresponding to the related evidence, that including today's argument and earlier. Give a small note, not necessary that you will have to write like a written argument. This point, this is the evidence of why it is not cannot be linked.
And thereafter, my lord, in the FIR, specifically Kamal Gurwa, the present accused is named. And now your lordship has pointed it out, if my lord Kamal Gurwa is named, then my lord, in his my lord cross-examination, he has stated that what the contents of he is not aware what the contents of the FIR. And because all the my lord,
Was written by police.
And he only.
Because he was not here, he was called by the son of the appellant.
And he has also stated in his report that he was unconscious for 3 days. Then how on the next day itself in the FIR he named?
Now, how can police name if he is unconscious?
Yes.
Problem is this, all these are double-edged sword. If we go in this line, then suppose if he is unconscious state, PW4, PW5, everybody says he was not in a position to talk. These are independent witnesses, though there are some suggestions that there is enmity between so and so, so and so. They initially knocked the door was not open, then the son opened the door, then they saw this, he was not in a position to talk. What is being said by the IO when he told the IO? That is very vital. When? Even if we rely on res judicata evidence, when, that is very vital. Suppose, so far the brother is concerned, we may say, if we want to convict, we may say that yes, 3 days he was unconscious. So proximity, these 3 days is to be deducted from the sequence of events because he was unconscious. The incident happened moment he gained conscious. He told his brother that it is the appellant who did it. Now the question is, if appellant had did it, why he has involved in his deposition 4 persons who were not even sent for trial, and he says that who inflicted what, I do not know. These are the contradicting things. Now, argue.
So, from the entire case, it is a fact that some is involved, all these family members.
But fact is to be proved.
For my satisfaction. Although my lord, the product is not evidence, without evidence, ultimately nothing will happen. And my lord, your lordship also knows that Kamal Gurwa is involved, my lord, not only he is directly involved, and in fact, my lord, it is only because of the Kamal Gurwa and his family members. This all together committed the offense. It is not because this offense is not for a single person to commit. To rope my lord, to both his hands of the accused person, then taking him to a bathroom, and thereafter my lord put fire on him by pouring kerosene, my lord, all these things.
Then that can be a very good ground not to rely on the injured victim, because he will say before the police and his brother that it is only Kamal, and his evidence, which is not possible for a single person, according to you, tidying him, pouring him, taking him from bedroom to bathroom, and in his deposition he says that these are the 4 persons, and rightly wrongly 1 person's involvement is ruled out, and IO's cross-examination, it was established that he even made the boss of that person and said that he was. not his plea of LAB was established. So how can we relying only on the this injured witness, a person can be convicted?
Anyway, regarding 106, section 6 will not come in.
Let me be frank, we thought of this route to convict Mr. Chaudhary's crime. But this route was also not so easy route. That's why we thought we should have his experience and knowledge to come into a just decision. We are here to take a just decision, not here to convict people on doubt. Yes.
Otherwise, from the lapse of investigation is very clear. Can be employed, yes, for them, everything, because ultimately, the sum of the present accused, Abhijit Purva, he was maybe, what is his age, I do not know, but he was also not examined.
Not examined.
Point of time, Abhijit Purva, he was present there, and because the statement of the other neighboring witnesses, he was the person who opened the door of the field, thereafter other person entered inside the house, and thereafter they all told the incident, and thereafter the victim recovered from the bathroom, and police was also informed, and in the statement of the interview on his stated that he informed the police, and that police officer IO was on patrolling duty. He get the information from the police officer immediately.
Those were established that it was information to police over phone, and he went and he got that people were already gathered, and his evidence is corroborated by the other. Yes, we after seeing the fire, we went there, we knocked the door was not even open. Then subsequently, after some time, the door was opened by the son. Then we entered, we found him in a discondition. In the meantime, police came, police went. So this is established. That is corroborated by the brother that I was so went to my place. I was called, I saw many people, body was, that the victim was taken, then I also accompanied. But I lost the affair next day, but he says that, yes, I do not know, I have not seen, and police returned the affair, I have signed it.
Because in his statement, I had recorded the statement of Joy Hazel on the statement of the IO. That is on P1 2004 to her civil hospital.
Okay, what is the cross-examination reading?
For clearance of the IO.
IO.
I had recorded the statement of Joy Hazulka twice. First, I had recorded his statement on 3/1/2004. Then again on 4/1/2004. Not only on 3/1/2004.
Okay.
There is note in the CD that as the victim was in injured condition, so it became necessary to take his statement again. Later on, and accordingly on 4/1/2004, I recorded his statement. I have not collected any medical opinion on 2/1/2004 about the health condition of the injured. It is not a fact that on 2/1/2004, after the occurrence, the injured was not revealed for the health condition of the injured. It is not the name of common law to me of pursuing him as such. In his statement given on 3/1/2004, and again on 4/1/2004, there was no any reflection by the injured that while he arrived at the house of Kamal Burua, sorry, madam.
I think there is some mix up or what. I think you have also given me one. I am having somewhere in the bundle, I think, clip bundle, where I have dictated some portion. Ah. So he said that there is nothing implicating on both the occasions.
Let me go ahead.
Hmm.
I had recorded the statement. He had verbally stated to me on 2/1/2004 after the occurrence the name of Kamal Burra. Witness Joy Hazarika had never stated before me that accused Kamal Burra had demanded money. Then in the event of failure of payment, had asked him to hand over the LIC policy to him. No had stated before me that Kamal Burra offered him tablet, which he refused to take it. Witness Sri Sandeep Kaur Thakur had never.
He damaged his own case.
Yes.
He has damaged his own case. He became smarter to bring everybody and Ujjwal, even hearing concluded, though matter was heard and reserved for judgment, while dictating the judgment, this court felt necessity of hearing the learned counsels further. Accordingly, matter was listed today. The learned counsel for the parties has advanced their argument on the queries made by this court. Accordingly, hearing is concluded. Matter reserved for judgment. You are outside?
Outside.
Keep it. Hmm.
For admission, item number 12.
Yes. This is hearing. Hearing or what?
Admission.
Why it was left here? Okay, how many admissions are there? Okay. What is this? Affidavit you have not filed. You have filed? Okay, the learned counsel for the parties prays that they may be granted some further time to file the affidavit in terms of the order dated 11/8/2023. Prayer is allowed. List this matter. Then after 2 weeks or after November. Huh? Give a date in November.
17th of November.
17th of
13.
Yes. Hmm.
He was married, but he on down that he is not lived with joint family. He lives separately. On that the government of there is a corporate, and the petitioner is the various level. The petitioner rented house in Guwahati and lives in Lebanon. And for my lord, his ever my lord, the my lord amount he is not able to pay my lord.
Mercy petition. You want to say mercy petition?
Yes, my lord, because admittedly he is on style of my. Admittedly, there is no dispute my lord, and wife also. And
Now you are paying how much?
my lord, I have already paid my lord. Yeah, and that my lord, one was issue my lord. I was arrested my lord. And at the when I was arrested, 30,000 rupees my lord. Thereafter 10,000 rupees. As per the.
Now, according to you, what is the reasonable maintenance?
4,000 my lord.
Too less. Why don't you have a talk and settle it? instead of not getting anything,
Not to wear that part of the one part cover, he did not pay. On part seven of it, he did not pay, and now out of. Right.
what did your husband do?
It is the school, as per my facilities.
Piece is the same, say daily, 10,000 giving on every month. Again, you married. What?
No, it's married. So for my circumstance, I have no evidence in marriage. Everything.
Here after puja. Pay, at least pay something. Otherwise, our next day will dismiss it. Do whatever you like. Problem is that if you can come to a negotiated settlement, instead of giving an awarding an amount which is not even been paid,
Yeah.
you will better prefer to be stay in a government accommodation. Instead of selling fees, you will be in a government accommodation and be orderly of some accused who are in jail, who are having high status, you will earn more. So you have try to have convince your client that, and you also 4,000 is not acceptable. 4,000 is not acceptable. You have an instruction. So far relating to area, we may make a long installment. 10,000 is you are paying now.
Yes, no.
Not paying 10,000 is awarded. Will if you give up reasonable proposal, we'll agree. You will also agree. Then we'll give an installments on long installment. But if nothing is done, we'll dismiss it. You inform your client. After puja, we are giving this time. As agreed to with the learned council for the parties, list this method. What do you do? Housewife doing something.
Next. Daughter started to be
What is the age of the daughter?
7.
She
Yes,
forget about her. Your daughter.
yes, sir. Today I was paying my lot, 30,000 pay, going to arrest 10,000 pay. But I have this position.
So we'll ask them to arrest you so that another for 20,000 come. That is a better way. We'll keep it pending here, and sometimes we'll say arrest him.
As per my information, it's there.
How can you contact? His phone is switched off, otherwise police will track him.
I will spread for them.
You have instruction. These matters should not be 10,000 is, I do not think he is a daily.
10,000, 4,000 from area and 6,000 from. Capital also.
Okay, we may lengthen the period and also reduce to an extent the thing, provided you agree and you continuously pay. Subject to that only, otherwise this order will revive. Have your instruction. Yes.
For hearing, item number 48.
What was this, Mr.?
That was collecting.
Ha.
254 conviction, child.
Ha. That next door neighbor. Next door neighbor. What was your argument? You wanted to show certain judgments. What were the charges?